20 to 30% of the estate for no reason, right? The laws are there for us to transfer these properties to our children and not have to pay for them to pay any estate taxes or to pay capital gains taxes, right? So, so I started studying about this trust and estates, talked to my dad because we were end up paying each one of our, myself and my two brothers, about $300,000 in capital gains taxes when we got the properties. Why? Because my dad had bought some properties about 30 years ago. He bought them about $200,000. Now, because of the way the market is, as I'm sure a lot of you know, it's about 1.5, right? So there's a lot of capital, there's a lot of profit in there. So I started studying, and that's what like my impetus behind this practice. So when you give a property, when you pass away, right? You're either going to give it by intestate, which is that you die without a will or a trust. Second, or a will. Third, by trust. Okay. Why do I push the trust, right? There are 4 basic reasons. First, you want to avoid your heirs. Again, the trust is not for you. The trust is for your children. It is for them not to have to go to court, okay? When you have a trust, you don't have to go to court. It basically take the trust instrument, to go to an attorney, and within 30 minutes to an hour, they're the trustees, right? Because you're going to make them successor trustees, right? So you avoid about 9 months worth of surrogates work. Second, you have paid, when you pay for the trust, that's the work, that's all that's needed. Whereas your children will have to hire an attorney, go to surrogates court. That costs a minimum of $7,000 to $8,000, as high as $12,000, right? Depending on the cost and how much of an estate you have. Again, you're paying for it up front. So their cost is really just about a couple $100 just to get an attorney, just to give them a certificate or an affidavit of trust that they're the successor trustee. Because the property is owned by the trust. There's no deed transfer that's needed at that point, all right? Third, the children will get what's called a stepped-up basis. Okay, what does that mean? So as I was telling you, let's say you bought the house. I'm very familiar with this area because I used to live up the block over by Brookville and 244th Street, between Brookville and Hook Creek. I've been there about 20 years. I'm going too fast? I'm so sorry. So the third thing is to get the stepped-up basis. Okay, and what does that mean? It means that you're going to get the appreciation, right, the fair market value of the property of when you pass away, not when you bought it, all right? So again, a lot of these areas I bought over here was 20 years ago about $350,000. When I did the appraisal, it was worth $650, right? So it's about $300,000 worth of gain. So our children would have to pay about 20% of that. You're looking at $60,000, right? That I've just saved them by putting the house into the trust. Again, as the profit goes up, you're looking at $200,000, $300,000. That's easy money, right? That's money that's being lost because we did not avail ourselves of this instrument, right? There was a big fight. If you heard AOC and Bernie Sanders years ago, they were fighting to remove the stepped-up basis, okay? So luckily, Senator Manchin vetoed it and did not vote for it, and now we have that, right? That has been continuing for the last, I think, 20, 30 years. As long as I remember, the tax code always had it. But that's real money that has to get paid, and if you don't have it, basically you have to sell the property, the same property that you've been saving to give them, right? Fourth, and which is the real most important thing, I think, is that we get to put this property into a asset protection trust for the children. So what does that mean? That means that when your children get the property, and in the event they get divorced, they will not lose the property. So it acts almost like like a prenuptial, right? They will not lose the property, right? Because most of the time, want to speak to this one? Okay. Most of the time, you know, when a lot of our customers, younger clients in our Bangladeshi community, when they're buying, their wives don't want to sign a prenuptial. So I said, listen, before you get married, put into a trust. So that's another way of acting like a prenuptial, right? If you have if you're young and you're not married, or you're not married and you're going to get married, just put it into a trust, okay? That will avoid the property being marital property. It will stay separate. Second, let's say now you're going to give it to your children, okay? You put it into an asset protection trust, okay? Again, that will serve as a barrier for divorce, okay? So these are the 4 reasons that we've been pushing it, and it's, you know, I mean, how do I say it? I mean, most people of color, we don't avail ourselves of it. We lose it. So I've been doing a ton of presentations at our mosque, tons of presentations on our news channels, and the reception has been great. Like, people are just, like, their mouth just drops, like they didn't know that this stuff existed. So there are, I'll get to you in a second. There are, again, it's there. The people in Congress, these are very rich people. Two things they hate. They hate taxes, okay? And they know their kid's gonna get divorced, right? So this is the thing that they've set up for us to avail ourselves. We just don't do it, right? And I guess across the board, I don't care if you're Indian, Pakistani, African, whatever the case may be, we just don't, because again, it's very complicated. Most of the attorneys don't know how to do it. I've been doing it now for several years. I have a partner that's been doing it for like close to 25 years. So we have really, a tremendous amount of experience at it. And we have trusts that are for, let's say you have a child that's autistic. We can set up a supplemental needs trust. Okay, so you can get, your child will be able to get aid, okay, and not have to lose their property. Okay, we have Medicaid trusts, right? So you'll be able to get, if you go into a home or you end up you need long-term care. Again, you're putting this into a Medicaid trust. Your children will still be able to get the property because Medicaid will not be allowed to go after non-probate assets, right? So again, these are various trusts that can deal with different situations. Okay. That's why I was appreciating Richard brought us here to speak to you about it. I'm sure there are tons of questions that you want to. I know I saw one lady that had a question. Yes, ma'am. What's that, ma'am?
I'll get that. I'll get it.
Yes.
I'll get it. No, you can keep your money. And if you want to ask a question, I've got two mics. Just show your hand.
Yes, I'm saying, what about the irrevocable trust?
Right. So these Medicaid trusts, S&T trusts, they are irrevocable trusts. Okay. So what happens? Oh, yes.
Now, if you have your trustee, there's revocable and irrevocable.
That is true.
Right?
Yes.
Okay. So, for instance, if I put it to a trustee and it's go into irrevocable trust, I can't do anything about that.
Okay. So good question, right? So a lot of the attorneys that do it, they do what's called non-grantor irrevocable trust. We don't. It's just law. I can't help it if a lot of attorneys don't know it. We do grantor, okay, irrevocable trust. So we have that the grantor reserves some rights in it. So they are allowed, you can be your own trustee of your trust, even though it's an asset irrevocable trust, okay? I have it for myself, okay? But again, there are, I forgot the section codes that allow that there's a powers of appointment and powers of revocation. So even though the irrevocable trust sounds so irrevocable, in New York, thank God, it is not so irrevocable. So, but yes, if you talk to many attorneys, they will not do. They will tell you, oh no, you can't be your trustee of your own trust. That is wrong. We do it. We have the law to support it. And again, like I was explaining to you, that this is just the experience that we have. So yes, that's a very good point. You do not have to worry. Even though we do an asset irrevocable trust for you, you will be the trustee of your own trust.
All right, I got a question.
Yes, where are you?
This way, buddy.
Oh, sorry.
I have got a trust,
Okay.
and I didn't know the difference between revocable and irrevocable. My house ran into disrepair after a while. We're going to talk about look back now, but I went to get a loan. You can't get a loan.
It is okay. Go ahead.
Well, you can't get a loan, but it is easy.
It is very easy. The only thing is with the loans,
Okay.
what we'll do is we can switch the deed out of the trust, put it into your name, okay, and then you'll get your loan, okay, and then we will switch it back into the trust, okay.
Interesting.
And then what we do is, if the lender has a problem with that, normally we write a letter to them explaining to them that it's the same guarantee, same guarantee, right? Same note that you're signing. Nothing has changed. We just changed it for his estate planning purposes, and they've accepted that.
Okay, can be done. All right, thank you.
Yes, ma'am. Oh, I think she's looking for it.
have a problem right now because my dad owned a house in Michigan, and I have him. But what I'm planning to do is the house is just in his name only. So I'm almost there. I got the deed paper and everything to sign off on because there's no one name in the house. It's just his name alone. And now he's like a Alzheimer's patient. So I'm struggling big time, both with Medicaid and the house and the deed. So with a lot of prayer and help, I got myself a deed paper. I happened to call the people them in Michigan about this thing.
Yeah, I don't know how you were able to get that deed in your name because if he has Alzheimer's.
She told me I could get the deed in my name.
Okay.
Because what happened, I went to the court in Michigan.
Okay.
And I have all those paperwork.
If the court appointed a guardian,
I am the guardian.
okay, so then the court
I am
appointed
the
you.
conservative.
Well, that's a different story, right? So that's what you want to avoid, right? So thank you so much for that question, right? So basically, she's spending all that time, money, and stress, right? That could have been avoided had it been in a trust, right? She would have been the trustee, and then you wouldn't have to worry about all of that stuff, right? Then we do other estate planning documents such as power of attorney, healthcare proxy, we do designation of remains, and then a pour over will. So if they do get another property and you don't get it into the trust, it pours over into the trust. And one thing I forgot to mention to you is that a trust is just a trust, right? It's like this vase that's empty or a bowl that's empty. You have to fund a trust, right? A lot of attorneys make this mistake. So we have to transfer the deed into the name of the trust, and then you have that protection that we're talking about.
Oh, so I have to transfer that and put it in the deed?
Yes, ma'am. You have to put it into the name of the trust. To avoid, again, I don't know Michigan law, but again, I'm sure it's similar to every other state. You will have to go to the surrogate's court if you don't, once he passes away. So the trust takes about 2 weeks to prepare, but if you have properties in Brooklyn, it takes about 2 years for the surrogate court to hear your case. So now, imagine if you're looking to collect rent, right? Imagine you want to do something, like the brother here was just saying, you want to do some kind of repairs in the house, you want to take a loan, you can't do anything, right, until you get this letter from the court, right? A letter is an administrator or administratrix, depending on who's applying, right? So you don't want to do that, right? And then I had this old Guyanese lady. She came into me. I felt so bad for her. She went to this attorney, and the attorney, she wanted a revocable trust. The attorney did an irrevocable trust for her, and he put himself as a trustee. I have it in front of me. I have it in my office, right? But because his selling point was, hey, you know what? What the nice lady was saying before, that you can't be the grantor, right? You can't be the trustee of your own trust. She says, listen, you can't be so I have to be the trustee for you, and I'm going to charge a commission to your heirs. So I called him up, and I was like, listen, I can't believe you did this. Well, she knew what she was doing. But next thing you know, I get a mail that basically says he's no longer the trustee. So, you got to be careful, right? I mean, you really need to go people that not because it's cheaper is better, right? You get what you pay for, and you really should come with some kind of recommendation history. Again, like I said, we've been doing it for 20 years. I have 0 complaints to the bar, and I just love what I do, right? And I go to everybody, whether I don't care, I don't even mind. Jew, Christian, doesn't make a difference to me, right? I just want, and if you don't even use me, that's fine. I want you to do it, okay? It's peace of mind, okay? Whether you want to use me or not, Richard brought me here. He didn't say to use me. He just said, listen, he's going to give you information, right? So whether it's me or somebody else, just do it. It's a great tool to get these assets to your children with no headache and no cost to you. Oh, yes.
Say for instance, you own a house. You want to put it in your child's name. You end up in the nursing home, or say you're homeowner. You want to put the house in your child's name. You end up in a nursing home or somewhere where you're getting Medicare. How long will Medicare go back to trace that the house was in your name?
Medicare is, everybody gets Medicare, right? So Medicaid, they have a 5-year look-back period.
Oh, okay.
Right? There's a 5-year look-back period, right? And one thing, I just want to touch on what you just said. Okay, so she's saying, I want to get the house to my kids, right? So do not put the house in your kid's name, now, right? They'll be the owner, and God forbid, I know in our community, they're always afraid that, that once the child gets married, the other, the new in-law is going to kick the parent out. It happens. It happens, okay? So what I do is I tell them, listen, just do the trust, okay? And you get to live in the property for as long as you live, okay? No one can kick you out of your house, okay? And if you do happen to give it to, let's say you got a really loving child, right? And you want to put the deed in his name. The problem is he doesn't get the stepped-up basis. He doesn't get the fair market value when you pass away. He gets it what you bought it for. So you really hurt your child, right? Number one. Number two, again, divorce. And number three, if he gets judgments, school loans, right? These are a major deal. My kid's got a huge amount of school loans, right? And if they can't pay it back, they're going to go after what she owns, right? I took care of that, right? That bad boy's tied up in an asset protection trust. They can't touch it. I don't care what they try to do, right? So, yes. Yes, ma'am.
If you take a trust here,
Yes.
start one here, is it valid in Jamaica?
So no. So you would, and that's another point. The answer is no. You would have to find out what the rules are in Jamaica, okay? But do not put when the trustee, please, when you meet the attorney, don't put a non-U.S. trustee. The reason we'll convert it from a domestic to a foreign trust, and then you'll be hit with these massive taxes, right? So don't make that mistake.
One question to you.
Yes, sir.
Could you just re-emphasize the difference between a will and a trust? Okay. And then she will have the next question.
Okay, great. So with the will, it's cheaper, right? But you get what you pay for, right? You don't get this asset protection, right? You still have to go to the surrogate's court, right? So you're wasting about 9 months, 6 to 9 months, in Queens, 2 years in Brooklyn, right? You don't get all of those benefits. The only benefit you get is a stepped-up basis. That's the only benefit you get. Other than that, you don't get any of those things. It doesn't prevent you from S&T trust. It doesn't prevent a medical trust, asset irrevocable trust. It doesn't give you any of those creditor protection trusts or medical bills. So it's really, I don't even do wills. If you want to know the truth, I don't do it because I think it's malpractice. It's really just not worth the paper it's written on. Yes.
Why is it? Why is it?
Okay, so I don't understand nothing about. I don't understand nothing. But recently, I'm single. I don't have any kids.
Yeah.
I am not married. So I put my sister's name on my property.
Oh.
Both property. I have one in Jamaica and I have one here.
Mm.
But I was wondering now, do I still need to do like what you're saying? Because initially I said to myself, okay, maybe what I'll do is write a will, so if anything happened to me, they can.
Every scenario is different, right?
Or
So
do I do something to protect? Because what Anne-Marie just said, what if something happened, I get sick and I go into a nursing home? I know that they go back 5 years.
yes.
How will that affect what I have and what I want to go to my family?
Yeah, I think it's going to affect you. Again, that half that you have, right? So I don't know, that's another. I want to just make sure I don't lose your point, but I don't want to lose this train of thought, right? So basically, when you put another person on, you are now tied to that person's heirs. So you put your sister on, right? And if she were to pass away, and you don't do it with what's called joint tenancy right of survivorship, and you just joint tenants with right of survivorship on the deed, right? So that means the survivor gets it, right? When you put joint tenants right of survivorship. But if you do tenants in common, okay, then if your sister were to pass away, then you're tied to her heirs. Her heirs would inherit her property, right? You would not be able to sell it. You would not be able to do anything on it, right? So, yeah, that's what you did when you put your sister on. So that's a problem, right? So now you really, I would take it out of your sister's name. Unless she's really, the person that's going to get it from you, just do it in a trust, right? I would just take it out of her name, put it into a trust, and then you give it to her, right? And you could put it in asset irrevocable trust. So God forbid she married. You see? Listen. All right. So that's that. So what we could, again, we could, we could have done it in you could have put it in a trust and you didn't have to worry about it. But listen, everybody has a concern, right? You had this concern, right? So it is, everybody has it, right? I mean, my brother just got divorced. His wife, his ex-wife, she just used, he was a doctor, and he is a doctor, and she just used them, right? There are some really unscrupulous people out there. I mean, they're just heartless, and he won there were 4 kids, 3, 5, 7, and 8. He won custody. That's how bad this lady is, right? And, I'm just telling you, you just have no idea. People preying on you. And they're your friend. They're going to come in and say, listen, you're older. I'm going to look after you, right? I'm going to look after you. I'm going to take care of you. What do you think they're going to do, Right? They're going to try. One day, going to be sleeping, and be next, this is going to happen, And, it's just, I try to, really think about it hard, really think about it again, because you can't afford not to do it. You're going to die. I'm going to die. We're going to die. So what are you going to do? Either you do nothing, and then your heirs just lost 30% that for the last 30 years you've been working to pay your house off, right? Then when they lose it to it, and then if they get divorced, they lose half of it. So now you've been working so hard to give it to your son-in-law or your daughter-in-law, right? That doesn't make sense to us. So my mother made sure of that. She was like, she tied that up. Yes, please.
So you recommend the irreversible trust and use yourself as your own trustee?
You can be your own trustee, yes.
Could you just, yes.
How what?
Could you just go over that part for me?
Yeah. So basically, there are certain codes under the EPTL that allow you to reserve some powers. Okay, where like a power of appointment, meaning you can remove the trustee, you can change some beneficiaries, you can do all types of stuff, right? It's just that they just don't want to make sure that your creditor, if you do get the income, your creditors will get the income. If you ever take the property back into your name, okay, your creditors will get it. But other than that, it's just, how do I even say? It's like the stepped-up basis. Like, what's the difference of when of not having a trust and having having a trust? The code, the IRS code says you get the fair market value of the property when you pass away. That's just law, right? So the law says that you can do an irrevocable trust, asset irrevocable trust, and you can also be the grantor. Now, you can also do non-grantor, right? Which is like you lose complete, it would be you give it to like another trustee, right? You put somebody else as a trustee. That's totally changes it, right? But now the taxes are different, right? You don't, the tax code changes on the income and all that stuff. So, and then you lose that control. So the people who made this law, they understand, right? But again, a lot of the attorneys that do it don't understand that part of it, and they just make it a blanket thing. You know what? I'd rather not get sued, right? They do it on a basis of CYA, right? They're just concerned of like, you know what? If I put somebody else, I'm okay. I can't get sued, right? In the event something happens, right? Because you as a grantor, if you're not using it properly, right, you could probably lose your status, right, as a trustee, right? If you start taking stuff in your name, right, you can open yourself up to creditors, right? So you just have to keep it separate, just like LLCs, right? Just like LLCs, right? You have to do stuff in the name of the LLC. Whenever you do transactions, you sign as a member, right? You don't sign as your personal name. When you transact, you always put the LLC up top, right? And then you have your name and you put member next to it, right? So these are things, and you keep your accounts separate. You don't pay personal bills with your LLC, right? So it's just law, right? It's just following the law, and you'll be protected.
Yes.
Question over here. Yes. Yeah. So if a person find him or herself with, say, 4 houses, and the person put all 4 houses in the trust, but then they decide, say, I'm going to sell 2 of the homes. Is it easy to sell after you put it in the trust?
Absolutely. So there's a couple questions on that one. I want to raise 2 points I want to raise on that. So first, if you're doing business, if the other 3 properties, for example, you have 1 primary, right, and 3 of them you're renting out, you would not want to put those 3 into the trust directly. Why is that? Because when you're doing business, I just said just now, right, if you're doing business, right, under your name, then you open yourself up to liability. So what we do is we put 3 separate LLCs, okay, and then you'll be the owner of that LLC. We do an assignment of that LLC and put the trust as the owner of that LLC. Now you can go ahead and do business under the LLC, right? Nobody even has to even know who's the owner of the LLC, right? Just as they don't know, right? If you do, a corporation can own an LLC, right? Another corporation can own an LLC, right? Nobody has to know who it is. So basically, we would just put it as 3 separate LLCs, assign it over to the trust, and then you're protected. And as far as selling, it's not a problem. I mean, most of my transactions that I deal with, and it's funny, that most of the white Americans, they have trust, man. They don't play around. They don't play around.
Yeah. I just want to give a personal testimony, and Sister Ford, you can ask. You know, recently my aunt died in Jamaica, and I was the executor, and she had quite a bit of wealth, but she had several bank accounts. Only one of the bank accounts had my mom's name on it, and it didn't have a lot of funds in it. So when she had a will, right? When she died, nobody could access the funds. They didn't even have enough funds to bury her because the will dies with you, and it has to go to probate, and it takes up to sometime 2-3 years to have it resolved, as opposed to a trust that lives after you die. So she died, and they never had enough money to bury her. The siblings had to get together to get the money to bury her. Of course, they got it back once the probate was over, but you know, that was her situation. Also, a will is cheap in the beginning. The trust is a little bit more expensive, but in the long run, you save a lot of money having a trust as opposed to a will.
And I think your executor you got compensated.
Exactly. The executor got, in Jamaica, I don't know here, 6%. The attorney will get also about 6% to probate the will, okay? So you're talking about, that could be up to 12% of her estate going in fees, plus all the fees that goes with it, the court fees and the title transfer and all that. So yes, it's cheaper to make a will as opposed to a trust, but in the long run, you save a lot of money with a trust as opposed to a will. Okay, Sister Ford.
Yes, but if the will is made up in a way, so for instance, if I say, you know, will it to you, and then it's written that if you passed away, whatever, this pair will get it. The only difference with the will and the trust, really, in my opinion, is the probate. And if no one contested, it wouldn't be that long.
How do you deal with creditors? How do you deal with divorce? You didn't address those. I told you 3 other issues, right? I told you, sorry, 2 other issues, right? So this trust is there for a generational transfer of wealth. That's what it's for. It's a generational transfer of wealth, okay? Our people of color have not used it because they don't appreciate the losses. Paying 20% of capital gains tax, and I know if a lot of you have bought 20, 30 years ago, your houses have doubled in price, okay? Yes. I know, I lived here, like I said. So so you're talking about $60,000, okay, that we are going to be able to avoid, right? And divorces, and which we've heard all personal stories from them, right? And some of you do have some children that are autistic. Some of you are going to be older and going to be needing nursing care, long-term care. This is stuff that will can't do that.
Okay, let me ask this question. How difficult is it for me to make that transfer from the irrevocable to the one you suggested I take? How difficult?
Well, I mean, you're saying I'm saying if you want to go take a loan, then we'd have to go do a deed transfer. We'd have to speak to somebody, right, the lender, and see how they would want it, right? And it's sometimes if we're able to speak to them, we can convince them. Usually we're able to talk to them. Like for example, your taxes. As an example, you have senior citizen taxes, right? Some of you got like some seniors. You have to write. Sometimes they take it away when they see their trust, so we have to write a letter, right, to the county and say, hey, you know what, to the registrar's office, say, listen, it's the same person, all we did is some estate planning technique, and they restore the senior citizen taxes, right? So I think it's just the attorney trying to act on your behalf. I can't give you any guarantee, right? We have to talk to it. I think somebody, Amir Malik, who introduced me to you, right? And Amir is a really great loan officer. This is somebody that we'll be able to speak to and take care of you. One way or the other, we're going to get you your loan.
Yeah. Quick question. Could you explain the difference between joint tenancy and tenancy in common?
Yes. Okay, so when one of this, it's just kind of very simple language, right? Basically is what it says, right? Joint tenancy with rights of survivorship, okay? So, and actually there's another terminology called tenants by the entirety, which is husband and wife. So they're not able, the tenants by entirety, husband and wife, they can, by putting into another deed, shatter that, you know, that protection that they have, right, as, that they have. But the joint tenants right of survivorship, the one survivor can give they can actually sell their share to somebody, all right? But it just means that the survivor. So let's say, you know, myself and you, we own a property together, and I'm like, listen, you know what? I have somebody that's going to take me out, pay me $50,000, and take over my share. I can actually do a deed in my name, without her signature, give it to somebody else, and now you're tied to that person, and then the survivor of you and that other person would get the property. Okay, and tenants in common basically means that there is no automatic. It's not by operation of law. When you pass away, that person would either have to have, you know, hopefully they had a will, or they would have died intestate. And again, you're tied to that person's heirs, right? So you're not the survivor, right? You wouldn't get the whole thing.
In terms of cost, what are we looking in terms of costs? I know we talk about a will is cheaper and it's less cost. And
you know, our trusts vary. I don't like to say.
Before you answer, is it also that once you do a trust, is there a fee that is paid over a period of time, or you know, how does that work?
So we charge. We take half up front, half at when we're finished. All right, and it's a one-time cost. So there's no maintenance on it. Right, you own it, and the deed is recorded. We give you the trust and the deed has been recorded, and you keep it and you put it in a safe place. As far as costs, all depends. Like this brother's got 4 properties, right? That would be a different price than if somebody had a single, you know, property, right? Depending if there's Medicaid involved, S&T's involved, right? So all of this, you know.
Does that mean that you're not going to give me an estimated figure?
Estimate period any between 4,000 and 7,000, depending on what you're. But that doesn't include the funding. So as I told you, we have to fund the trust. So we got to do a deed transfer. Okay. So we charge $500 for the deed transfer. That's not us. That goes to Queens County. Okay. They charge a recording fee with the ACRIS, right? And that's just preparation of the deed, ACRIS, and the filing fee. So let's say.
And when you were talking a while ago where you said that if someone have a trust and someone die, if they have a will or if they don't have a will, when you have a trust, does it also recommend that you still do a will?
No, it's that it has the same provisions that a will incorporates the you know, the bequests, right, or divide, right. So if you're giving money, if you're giving property, it's all incorporated. You don't need you have a pour over will. So let's say you bought another property and you didn't put it into a trust. Well, that one property would be probated, and then that judge would then say, okay, here's a letter, put it into the name of that trust. So it pours over.
I have one more question. It's about the revocable and irrevocable trust. Okay, say for instance, if I want, say, my daughter to be my trustee, what kind of trust she's not living with me. So what do I have to do, revocable or irrevocable? Which one?
I'd have to sit with you, right? And I spend about an hour with you, right? And I do this massive intake. I can't give you an answer because I don't know your situation. I got to find out.
No, what I'm trying to say, because I tried it before, and because she's not living with me, the lawyer said I could only do irrevocable trust. I could not do revocable.
I don't know why that would be. That doesn't make sense to me at all.
No, and that's coming from Sullivan and Connors and Sullivan and the Bayside.
I don't care.
So could you explain that?
I don't know. I mean, that doesn't make sense to me. I mean, does that even make common sense to you? That the only person you can name as a trustee is the person who lives with you?
No, in the house with me.
That's what I'm saying. Does that make sense that you can only name a trustee?
And it has to go with your age, and it has to go with a lot of things. No. It's not just you're just going to do irrevocable or revocable trust. There's a lot of things entails in it.
Okay, I'm just saying common sense. It seems like if based on what Connors and whoever it is says, you can only give your property to a trustee who lives in your house. That doesn't really make sense.
Set it up. It's either could be irrevocable or revocable.
That's true. I could set up an irrevocable.
That's what I'm asking.
Yeah, I could set up either one for you. That's not a problem. No. No. As long as they're a U.S. citizen and they live in the United States, that's all that's required. But again, that's just kind of common sense, I would think. But anyway, yeah. I mean, that's what. Any other questions you have? Oh, yes.
Earlier on, you mentioned something about Medicaid.
Yes.
If somebody were getting Medicaid, right, and they have a property, does Medicaid come back and take whatever money they give to them?
Yeah, so the Medicaid, I had this conversation with my partner about it. So basically, when it's they really go after you when you're doing that nursing care and long-term care, all right? That's when they really come after. They're not wasting your time on prescriptions and that kind of stuff. But when you're owing $150,000, $180,000, they need to get their money, right? And you'll sign something that says basically, they're going to look at your assets, they're going to look at your deeds, and they're like, their eyes pop up when they don't see that trust, that Medicaid trust. They're like, all right, because they know they're going to get paid, right? They love to give you that money, right? So just beware, be smart, just avail yourself of it, and again, not to do with me. You can go with anybody else, but just there are mechanisms to protect it for your kids, so that the Medicaid doesn't come after on the big stuff.
Do they only come at property or also
anything you own?
Saving?
Yeah, anything you own, anything that's in your anything that you own. Anything you own. Yeah, you got a couple $100,000. Maybe you have a life insurance. You pass away, that bad boy hits into your bank account. They're going after it. All right?
You get help from the government and you have a lawsuit and you get some money, they'll
everything.
Okay.
Anything that you own, right?
So
right?
like if you have some money, right, and you put it under your grandkid's name.
Okay. Yeah, they would not be able to get that. The grandchildren actually own the cash. Is that what you're saying?
You turn it over. Instead of you are the owner, right? And you have grandkids. Instead of the money being on your name, you put it on your grandkids' name.
Okay, but you can do that, but now you just opened yourself up, right? I mean, now your grandkids own the property, right? They own your savings account, right? And I see my niece and nephew, man, I wouldn't want to trust them with anything. All right? I won't want to trust these kids with anything because, next thing my poor dad, he's got the iPhone and, he's sleeping and then the kid puts the phone up to his face and runs away to unlock the phone. And then he's using it. Next thing you know, my dad's got like a $500 bill for Mind Blocks or Roadblocks or some crap. Right? Dude, that's just they have no sense. This generation, the generation, your grandchildren, they have no sense of money. They have no sense. The more trust they do, we put it into disaster protection. Why? Because to protect them from themselves. Right? Now, one of the things that we do, that we like to do, is we do this thing called a trust protector. So let's say you have like this nice lady here that she's kind of like antitrust, but we could put a trust protector. All right. So let's say you have another third party that will oversee the trust. So you can name somebody as your trustee. Let's say you put your brother or whoever. You can put just your children. We could put a trust protector to kind of oversee to make sure that they're doing fulfilling your intent of the trust, right? And we have trust advisors. Again, you could put a third person that looks over the financial part of your trust. Like the brother's got 4 properties, right? You want somebody out there to making sure that the properties are being rented, that they're not in disrepair, so you have, and again, a trustee, maybe busy, right? But at least you have this advisor saying, listen, if you're not going to do it, I'm going to remove you, right? And that trust advisor and trust protector can do that.
And to your question, right? You protect your money from the government, but then you open up yourself to a host of other issues.
Yes, 100%.
Just,
Yep.
Go ahead.
Okay, next question. Is if someone should come in and sit with you, is there a consultation fee?
No, I don't charge.
I'm sorry, I'm all about the money. Listen, I have to know. Oh, the question is there a consultation fee? Do I
No.
need to pay him just to
No, we don't. I don't charge. I don't charge. But I can charge if you have a problem with that. Okay. Okay.
This is just a quick question.
Yes.
This is just
Yes.
a quick question. You
Yes, sir.
said if the person is a U.S. citizen and if they live in the United States, suppose the person is a U.S. citizen, but they do not live in the United States.
Yeah, I mean, it's just a matter of just being practical, right? I mean, who's going to notify them? How do they reach them, right? So that's why we always try to advise everybody to try to keep that, the trustee in the United States.
Just for that, but
Yeah, just practical purposes, that's right. Because I have a lot of the Bangladeshi clients that we have. I mean, they don't have anybody here, and they want to name their brother or whatever in Bangladesh. I said, listen, you can't because they're not a U.S. citizen, and the taxes, for example, income. Let's say this brother's got 4 properties, and he's making $15,000 in rent. Okay, the trust would if it's a grantor trust, it would be under his ordinary income. He doesn't need a separate EIN number, okay? But if he does it under a non-grantor trust, where he gives everything over to this trustee and he has no control over it, the trust income, he would end up paying 37% of anything above $12,000.
No, you see, the reason why I said it because,
Right.
With everything going on, sometimes, you have family members that are U.S. citizens, but they're not living in the United States. They live outside of the United States,
Yeah.
and they can be reachable because some people have
Then
mailbox
I don't see it as a problem then.
Okay, that's what I wanted to be clear about that.
Yeah.
Thank you.
No problem.
So I have another testimony. I have a friend, well, not a friend, I know someone who the father transferred the deed in the son's name in order to get help from the government, right? The son took out a home equity loan, actually several home equity loans, and he wasn't able to pay it back, and eventually they lost the home.
Now, one of the things, I don't know, again, I don't advocate it at all. I'm going to have to hire Richard to come work for me because he's great. Because if you're not listening to that, I mean, these are the things that happen, right? I can make it up. I mean, he's one of your own, congregants, and he's telling you from his heart, right? What we do say sometimes, right? It's just the person wants to give the property to their child. We would put what's called a life estate, right? So we give you a life estate on the property, right? So that means that you can live in the property, okay, for as long as you live, right? And that person would have to come and sign. If you ever sell it, that person would have to sign. And if there was ever a loan, that person would have to sign, right? So it acts as a check if you want to do that. But again, I don't know why you would want to put your children on. It just doesn't make sense.
And I'm telling you this, I'm not saying not to do anything, but I'm saying just be careful when you do certain things. It may seem like the right thing to do, the logical thing to do, but oftentimes
dangerous. Absolutely.
There are consequences. Right? Any more questions? Hold on, Elder.
Anyone getting into any situation, seek counsel before you make any deals. You understand? Because my house is in disrepair and I can't borrow a penny. But now he has opened this door for me. You see? You can't borrow.
We're gonna try it. We're gonna try. You just make sure.
You know what you're getting into. All right? That's all I gotta say.
Yes, sir.
Yeah, I had heard a story a while back. This woman, she put her mother into a retirement home, right? And the mother was, I guess she was early onset dementia. For whatever reason, the nursing home made this woman sign some papers, and somewhere in the fine print, I guess it mentioned something about her house. So the woman signed away her house without even realizing it. And the thing is, once the dementia got bad, right, the daughter wondered, why would you even have her sign if you knew she was in that state? So what do you do in a situation like that when you put your parents into a retirement home, but then the retirement home does something this heinous, knowing that the person is.
I mean, you can't stop fraud, right? I mean, that's just a fraudulent home, right? So you can't stop fraud, right? So it's hire an attorney to undo that whole process, right? I mean, you'd have to spend some money to hire a really good litigation attorney to undo it, which I don't see any problem in getting that undone. But you can't stop fraud, right? That was a big epidemic down in Brooklyn. People just signing out deeds like crazy, and poor people didn't even know, right? But yeah, you can't stop fraud. I don't get into the actual nursing home part, but I know that there is a ton of agreements that you have to sign. But again, I'm not a specialist on nursing homes. But yeah, I would have somebody look at those documents before signing them and advise you accordingly.
Go ahead.
But that would not surprise me. Because again, the nursing home is looking to get their money back.
Yeah,
yes. Yes, sir.
That's a question.
Yes, sir.
There's a certain woman that I know. She met somebody who was supposed to be a real estate agent, and the person told her they're going to buy the property from her. So they did all the documents for purchasing the property, and had her sign the property over to them. She didn't realize she was signing the property over to them. Then they promised her that they're going to pay her for the property because, you know, I'm a big real estate. I got a lot of money. I could give you $500,000 on the blink. But they never pay. And after, I think, a couple of years, when she asked about it, she was told that the period of limitation has passed. And so she has lost the property, and he now owns it. I don't know if there's anything like that.
Yeah,
that
I got 2 letters for that DA. You know, like go to district attorney's office, and then they'll get that property back for her. Obviously, it's fraud, right?
Yeah.
You know, and again.
Yeah, but what the person did, as soon as they got the property in their name, they took a loan on the property.
Yeah, I mean, then.
A big loan.
Yeah. So when that happens, right? I mean, the lender runs that risk, right? I mean, clearly they would have seen a deed transfer for 0 consideration, right? So I mean, they got to be kind of brainless to give a loan to somebody like that, right? So when they have to ask a lot of questions, right? And the title company, most likely, if the title company's stupid to insure, then they get title insurance. The lender will get paid, okay, and then we get the deed back. Right, so a title company would just pay the lender back for a lost loan because they insured a property that they weren't supposed to insure, right? So that's what I would do. And again, call the DA's office. That usually gets the property back real fast.
Yeah, it's a common thing in New York.
Yeah.
It's common.
Yeah.
I spoke to somebody about that lawyer. She said that they got so many cases with that situation.
Yeah, Brooklyn is
that
infested
most
with
likely they would never get back the property because there's so many cases they got.
Well, listen, you got to hire the right attorneys, and you can get it back. It's just whoever the squeaky wheel gets the oil, right? So you keep fighting for it, you'll get your property back. But again, you have to have the money. You got to have the money, right? So, yeah, I mean, I just want to make sure we just if you have any other questions on trusts and estates, I just want to deal with that. And then,
any other questions?
And then anybody, please, I gave you my flyer. I gave you like a little summary of the trust, right? You can hold that up.
I do have all the contact information.
Right, and that's got my phone number, address, and I'd be more than happy to meet with you and discuss, further if you'd like. And I just want to thank you so much for opening up your congregation to me and letting me speak to you. So I was just afraid. But when you saw this, you were like, "What is he doing here?" No, I'm just playing with you. No, we're good. Thank you so much. Great thing. Any other questions? If not, we got a board meeting coming up soon.
Yes. All right. No other question, right? So let us give a round of applause for Mr. Baksh. So So I have his contact information, so if anybody wants to contact him, let me know. I have the information here also, all right? Good, all right. Yeah.